Good afternoon, everyone. Thanks for joining us. I'm Wayne Brow, the Program Director for Technology and Innovation at the R Street Institute. And we're working on an issue today that I think is important and is only going to be growing in terms of the concerns and potential impacts on both innovation as well as economic growth. And that is the role of the ITC in the overall picture of the patent process and patent enforcement, and potential adverse impacts that are coming out of the International Trade Commission. So today I have a group of people here that I wanted to introduce. First of all, we have Bill Jenks, who is an associate fellow with the R Street Institute. We are looking at the ITC. We've had a ITC policy blog in the past, and we've sort of re-upped that with Bill's addition to our team, where we will be covering the cases that go before the ITC, what possibilities for reform of the ITC are coming up, and basically all things ITC. So that we are again launching that in our blog. So please do follow the R Street blog and then sign up for our ITC policy program, so you can get the latest information on that. And then we also have Tara Hairston from the Alliance for Automotive Innovation, who looks at these impacts of the ITC proceedings and other patent questions and their impact on the automotive industry. And then we also have Bo Phillips, who's the Executive Director of US Made, which is a group of American manufacturers who are facing some of the sort of fallout from what's happening at the ITC. So I'll let each of these speakers provide a quick introduction of where they're coming from and why this is important to them, and then we'll just break it into an overall conversation. And Bill, since you're now our new R Street Institute associate, I will start with you. Bill, you're on mute.
Terrible beginning. I'm Bill Jenks, and I've been brought into R Street because I have a background in all things patent law. I've done a lot of work across all the venues of patent law, a lot of patent issues and appeals, some ITC work as well. And I'm very interested in the scope of patent enforcement in the United States, and particularly when that scope gets out of whack. And I think that's something that's happened at the ITC. And I think that's something we're going to be exploring in a data-driven way in our blog. And we have a lot of great stuff in our archive on our blog as well. But I would say that where we're going with this is going to bring out, in a way that people who aren't ITC mavens can see what's going on at the ITC, not only in individual cases, but in the ITC group. So with that, I'll turn it over to
Great. Thank you, Bill. Tara, do you want to do a quick introduction?
Sure. Thank you, Wayne, and thank you to R Street Institute for putting this event together and for having me. So my name is Tara Hairston. As Wayne mentioned, I work at the Alliance for Automotive Innovation, or as we go by Auto Innovators for short. And we represent nearly 98% of the auto manufacturers that produce, the manufacturers that produce nearly 98% of the vehicles sold in the US. But we also represent original equipment suppliers, technology companies, autonomous vehicle startups, as well as other value chain members. And one of the reasons that the ITC, or the International Trade Commission, is important to the automotive industry is that the automotive industry and their companies are amongst the largest patent holders in the world. If you look at, for example, the Harity Top 300, which is a list of the top patent holders globally, 55% of our members are on that list, and of that 55%, 70% are actually in the top 100. So R&D, patents, intellectual property rights more broadly are very important to the automotive industry. But not only that, the ITC in particular and other venues for resolving or addressing issues related to patent infringement are important because, in addition to being inventors, automotive companies often find themselves defendants or respondents in these types of cases. And so it's really important that the venues where these cases are being heard or adjudicated, really have a balanced approach to not only innovation and competitiveness, but also, the rights of, both sides of a particular case. So that's why we care about these issues and why we're so happy to be participating in today's event.
Great, thanks, Tara. Bo, last but not least, US Made.
Oh, very much least, but that's okay. Thanks, I appreciate it. US-based members run the gamut from large manufacturers like automakers and highly specialized makers of microchips to the makers of more leisurely consumer products like Titleist golf balls and most of the nation's small and medium-sized recreational boats. Like most US manufacturers, most of our members employ fewer than 500 employees. Some of our manufacturer members have a few dozen employees or even less, and are characterized by any business standard as small businesses. For our larger members, litigation is part of the price of doing business. It stinks, but they expect it. For our smaller members, litigation can be an existential threat. And like most manufacturers, US-based members went into the manufacturing with their eyes wide open about the challenges of being a manufacturer in the US, right? Cost of capital, which we just kind of hit on yesterday, supply chain issues, labor market, right? These are things that manufacturers know they're going to face. What they never necessarily expected was sort of an entire industry built around a profit motivation that was only satisfied if sort of specious, abusive litigation or the threat thereof was successful in extorting a payment that under no other circumstance would ever be paid. And the ITC has unfortunately simply become just another tool in the toolbox of those who use that business model. We're shaking down my members for royalties that they would not possibly pay. But for the possibility of a domestic product ban, the sword of Damocles, ultimate sword of Damocles, hanging over their head. I suspect most people who are watching something like this know that 60% of all patent litigation is filed by MPEs. What you may not know is that 50% of all patent litigation is filed against domestic American manufacturers. 50%, over 50% of all patent infringement litigation in the US is filed against American manufacturers. So this whole it's all Google, Amazon thing, it's all software, or it's all pharma, is a little bit 10 years old. It's a little bit pre-AIA. This is an American manufacturing issue these days. Our members have availed themselves of the IPR process. So for us, seeing FinTIV decisions being made not just based on what's happening in courts in Waco, but based on what's happening in the ITC, it was a very big wake-up call and a real problem. And I think that's where a lot of our energy is focused as the new director starts taking comments on director review. And that's what our interest is to a degree in being here today.
Thanks, Bo. Yeah, and you brought up a lot of questions and issues that I think it's worth delving into, because I'm sure it gets very complicated quickly when we're talking about patent policy, and suddenly the International Trade Commission is the key player in this arena. And for folks who are interested in the issue and perhaps maybe don't have a lot of background in it, I think it's important to look at how we got to where we are today, what the ITC is and what it does, and how it interacts with the rest of the patent system. Because as you mentioned, there's decisions over at the patent office and in the PTAB that are directly impacted by what's happening here. So maybe Bill, if you could just maybe provide a little background and what is the ITC? And how did it sort of come front and center in this whole process of patent infringement questions?
Well, I think if you're into this, the first thing to know is that the T in ITC is trade. And what that means is the ITC operates on the border between the United States and all other nations. In other words, they're there to govern over imports into the United States. There is a statute that's been around for a long time that allows the ITC to exclude items that would harm or the statute destroy or substantially injure domestic industry from their importation if that importation involves unfair acts. One of the unfair acts that exists today in the statute is patent infringement along with copyright infringement, trademark infringement. So the ITC looks at imports and decides whether or not they violate someone's patent rights or their copyright rights. Typically, it's patent rights. And the main point that I want you to take away from this is that the ITC has one way of resolving these disputes, and that is to exclude or not to exclude the infringing imports. What that means is that effectively any successful patent holder at the ITC can stop importation In the same way that if they went to district court and they were successful in district court, they could stop the importation or the making and using and selling in the United States if they got an injunction. The difference is in district court, ever since eBay, injunctions for patent rights holders have relied on the notion that you have to have irreparable harm in order to get that injunction. That's not true at the ITC. You merely have to have a domestic industry that's linked to the patent rights, and then you can stop importing perhaps the only product that the company sells. It's, as Bo was alluding to, this creates a asymmetry between what patent rights give you in district court, what patent rights are writ large in our law, and what patent rights may give you in the ITC, because certain non-practicing entities, and if you want statistics, 20% of ITC cases in the last few years have been brought by non-practicing entities, can bring a suit in the ITC and stop cold imports. Why do they want to do that? It's not to protect what they're doing in the United States. They're at best a licensing arm. It's to stop the imports to drive up what the sell to a level that they could not get, even if they got patent infringement found in the district court and damages for.
Okay, thanks. And I don't know, Bo, maybe if you could follow up on that, because clearly there's federal courts out there that can handle these patent issues, but the ITC has, for some reason, attracted a certain type of case and it's becoming more and more prominent over time. And I'm sure manufacturers in the U.S. are seeing this as people choosing the ITC as an alternative venue for reasons of maybe it's because of the ability to have that injunction, which in the federal courts it's much more difficult after the Supreme Court sort of curtailed that. Can you talk about how you see people using the ITC strategically against your members?
Sure, absolutely. I mean, look, the folks who are bringing cases against my members, who are typically MPEs, who are typically using patents of dubious quality, are looking at this in the, who are funded by typically outside funders now, sovereign wealth funds, hedge funds, Wall Street, and therefore they have obligations to produce, right? They're under the gun to produce profits like never before. These funds are promising returns of 20% and more, so they've really got to deliver. And so they're looking for the best return they can get. This is just another wealth generating operation. So as they sit down and strategically look at the best way to sue my members, shake down my members, they're looking for the venues where they can either inflict the most pain or threaten to inflict the most pain to get the quickest and largest settlements possible. The ITC is obviously ideal for that because, as Bill said, it has only one remedy. It can't issue a corrective remedy. It can't issue a money remedy. It can only issue an exclusion order. And there isn't a lawyer in any one of my members that'll ever tell their CEO, oh, this is such a slam dunk. We're going to win this so absolutely that we shouldn't consider settling. Don't worry, boss. There's no chance we're going to get an exclusion order. You don't have to worry about our products being shut off in the United States. No lawyer would ever make that promise to their boss, to their client. They can't. Even if it's 1,000% they're going to win, they can't make that promise. And so they tell them to settle. And that's why the ITC is so attractive. For us, the ITC, it's great that you're focused on and looking at the ITC, but for us, the ITC is just one of the holes in a large game of whack-a-mole. The courts in Texas and Waco are another one of those holes, right? Fixing FinTIV at the U.S. Patent and Trademark Office is another one of those. So we're whacking here, we're whacking there, and they're just coming up somewhere else as we do so. That's their job. That's what they're incented to do. And so that's why the ITC is so very attractive.
Okay, great. And Tara, for you, obviously you noted how many patents that your members hold, and at the same time you've got these non-practicing entities that get these huge portfolios of patents and look for potential people to sue for practicing those patents. How does that affect you and your industries when you look at the ability of the NPEs to use the ITC versus a traditional court remedy in terms of having your members being able to stay on the cutting edge, innovate, and provide products that are what consumers are looking for.
Sure. Thanks, Wayne, for the question. And I'm probably going to be building off some of the comments that Bo and Bill have also shared as well. But I would say that, you know, the automotive industry and transportation more generally is really on a path for, you know, real innovation that's already happening now. You know, you're hearing about electric vehicles and you know, talking about, you know, extended range and all these sorts of technologies that are going into electrification and the commitments of the industry in that particular space. You also have, you know, technologies that are being incorporated into vehicles related to automation or connectivity. And so as you're increasingly incorporating technology and, you know, the inputs and parts and components that facilitate those technologies, you are starting to see a lot of non-practicing entities or NPEs, you know, sue automakers or file complaints at the International Trade Commission. And so where I kind of see this, and like I said, I'm going to probably be picking up on some themes that have already been stated, is that this really has an intersection, as Bo mentioned, with the broader kind of ecosystem, what's happening in district court, what's happening at the Patent and Trademark Office. But from an industry perspective, it's also impacting US manufacturing and these broader trends in the industry. And what I mean by that is that supply chains are global. So, you know, you have the auto industry, you know, the largest manufacturing sector here in the United States, responsible for nearly 10 million jobs and nearly 5.5% of US GDP. But they also need access to parts and components from around the world in order to build, manufacture, and assemble those products here in the US. So when you have an NPE or a non-practicing entity alleging patent infringement at the International Trade Commission, a lot of times it's on a very small component, something like maybe a microchip or a semiconductor. And as we're all very aware, there has been a severe semiconductor shortage these past few years that has been impacted by COVID and factory shutdowns around the world. And that has severely impacted, you know, vehicle production here in the US. We've seen significant reductions in the amount of vehicles produced year over year as a result of, you know, semiconductor supply chain challenges and others. So when you have the potential of alleging infringement on a small component, but then these complainants are requesting that the entire vehicle is prohibited from being imported. You know, those threats of exclusion orders, as Bo mentioned, that sword of Damocles is really impactful because, you know, no company, as Bo said, is going to want to you know, take that risk that their entire vehicle cannot be, you know, and not just the vehicle, but like, you know, their entire production can no longer be sold and because it cannot be imported. So it's really kind of important to think about not just in terms of the quote unquote fairness of how the ITC operates, but how that intersects with, you know, the push to, you know, reshore US manufacturing, which the automotive industry and other sectors have all committed to, but also these broader trends in the industry that is leading to increased innovation and the competitiveness of the United States when it comes to these technological trends.
Great, thanks. And Bill, just from your perspective, you know, this whole notion of these little things stopping bigger projects, you know, we see a lot of these fights playing out in the tech space as well as in the manufacturing space. Do you have any thoughts or ideas of how we see this playing out in various sectors of the economy?
Oh, absolutely. I think first Tara hit it right on the head, which is we now see a lot of ITC litigation about some little component of some big thing. And her group basically has the biggest thing. We have the entire car in some cases being kept out because of something that is this small that's part of the navigation system, some other thing. Or at least that's what the push to get the ITC to do is more and more. But that's not just limited to the automotive. Sometimes we see things that are small, like your phone, that are being kept out or being attacked in the ITC over, say, a software patent that covers one functionality. There's a case over the Apple Watch, which maybe has hundreds of functions, and including health functions. And LiveCore has brought a suit in the ITC to keep out the Apple Watch because of one of those health functions. It's the AFib relationship. Not just big things, but little things that are really covered by a lot of innovation, a lot of patents that are where in the ITC, MPEs are trying to keep them out based on one patent, on one function. This is, I call it the big thing to the little thing keeps out the big thing problem. And it goes from manufacturing to high tech imports and everything. I think.
Great, thanks. And now, maybe it just to sort of compare the ITC and its behavior to others, because obviously any system it sets up incentives and disincentives to use it. And can you just sort of Bill, maybe walk us through quickly what the process is at the ITC? How does they do these section 367 hearings to look at these unfair trade practices, and when one of these is being played out, what are the steps that go through that process?
So the ITC, the traditional use of the ITC is they can stop and very quickly at the border infringing imports that in order to protect American industry. And so at the ITC, everything has an analogy to district court, but it goes very quickly. For example, even starting with the complaint, the patent holder for the Section 337 action typically has to file a complaint that is detailed about what the infringement is and what their domestic industry. Now, domestic industry was expanded. The definition of domestic industry was expanded to things people might not include in domestic industry, such as not just investment in plants and manufacturing, but also research and development. And the big thing is investment that we're having to do with investment in licensing. So you have to prove you are a domestic industry. But if you can do that through licensing, you may be able to develop licenses just through lawsuits that are patentable, because a settlement is almost always effectively a license. So the complaint comes in with detailed infringement allegations and allegations about this domestic industry, and it proceeds pretty much as you would expect a district court case to go, but everything goes faster because the ITC has a goal of getting everything out in a year from the time of the complaint, or 18 months depending on the case. So, but in terms of discovery, it's very expensive because it goes very quickly. And of course, if there's an interview, or particularly a patent assertion entity that's only in the business of acquiring patents, which is more and more at the ITC, you have virtually no expense in your discovery, but the manufacturer, the importer, whoever it is that's under the gun, may have a large business, and they have to take away employee time. I think there's employee time. They have to do a search. They have to have a freeze on everything, and they basically have to halt production in a significant way just to comply with these very fast standards for discovery. From once the discovery is completed, that's what you have to say. You'll have a hearing at the ITC in front of an ALJ. That's an administrative law judge who has experience in 337 cases, who will decide typically everything, but sometimes domestic industry and public interest issues are saved for the commission itself. Within the ITC, once you get your result from your ALJ, which will certainly decide whether or not there's infringement and recommend whether an exclusion order should exist, then you have the opportunity, whoever is dissatisfied with the ALJ, to go to the commission itself, which in a way, kind of like the Supreme Court, they can pick and choose what they're going to review from the initial determination. If they decide not to review something, that there's actually a 60-day period in which you can the U.S. Trade Representative, as representative of the president, to stop the order from going into effect. And from there, an appeal would go if the president decides not to act, and there's only a handful of cases over the last 50 years where the president has intervened, you go to the federal circuit for an appeal of the merits of the case. What I would say goes along in these cases, but isn't really getting the importance it should, is to look at the public interest factor. Public interest factors are something that the district courts always have to consider before they issue an injunction, and the ITC is obliged by statute to consider it as well. Unfortunately, we see a very narrow and strict interpretation of what is in the public interest when it comes to these exclusion orders. So you won't find very many commission cases where the public interest actually plays a role and prevents an exclusion order from going into effect.
Okay, great. Thanks for the overview. And Bo, if I could turn to you for a second, and it's something you've touched on a couple times, is the interplay between the ITC and the Patent Office itself and what it's doing. Because we know there's been, the patent systems had sort of a long history of trying to find the proper balance between, protecting innovators and avoiding excess monopoly rents going to various groups through the patent system. And one of the things we see, the Americans Invents Act created the PTAB and the inter partes review process as a way to look at patent eligibility and look at what patents are doing in terms of innovation and in terms of preventing others from actually producing their own products. So what the ITC is doing is that, how does that, because we've seen these debates over what PTAB does and how it makes its decisions. And I think the last director of the Patent Office had sort of changed some of the administrative rules in ways that sort of threaten PTAB's independence to make some of these decisions. And how does the ITC play into that?
Yeah, so I mean, look, broadly, patents are important. They're incredibly important. They do play a role in fostering innovation. And as you said, there needs to be a balance between legitimate protection of IP rights, of good IP that contributes to innovation on the one hand, and on the other hand, preventing misuse and abuse of poor quality IP, because there just is too much poor quality IP. The best solution for that, of course, would be to improve patent quality at the front end of the process, right? To have better quality patents coming out of the patent office. Everybody seems to have the same solution for that. More money, more money, more money. Yes, they need more money. That is not the right solution or the only solution. There are plenty of good solutions coming from plenty of smart people. We have our own ideas that we've given to the director, some of which we haven't heard from anybody else, so we think they're kind of novel and smart. Other people also have novel, smart solutions they've, I'm sure, given to the director. Hopefully some of those will be implemented and they don't cost a lot of money. That's ultimately the best solution. And it's also, we acknowledge, a little utopian, right? It's not going to magically solve all the world's problems. Just today, we saw two former patent directors who are patent today litigators who work for royalty companies and branded pharma companies, joining with some former jurists to form yet another moneyed, royalty group funded entity that's going to contribute to the public dialogue by telling lawmakers lots of things that are insanely patent maximalist, right? So this milieu will go on and on and on forever as we play whack-a-mole. The interplay for us, comes unfortunately when we are seeing very good work being done at the PTAB by expert administrative law judges who are either patent examiners, patent lawyers, or both, who have degrees in science and technology and experience working as engineers or technologists for scientists, who, contrary to what's being asserted by patent maximalists, are not all former Google lawyers, who are providing very thoughtful reviews of patents, whose reviews are being upheld at the federal circuit as frequently as district court reviews are, on the one hand. And then we have the ITC, which basically has one remedy and is not in a position to judge validity. So we think, and then of course you have district courts, which are trying very hard, I think, for the most part, but you have lay juries with judges who, for the most part, are not experienced in patent law, often reviewing incredibly sophisticated things And in mock trial sessions, you hear, your mock juries saying the most insane things on God's good earth about how they're going to rule. Just things that have nothing to do with the facts, nothing to do with the law, and everything to do with passion. So we think that the passage of the AIA, our members think, was a godsend. We think the IPR is an important tool. We don't think it should be overused, nor do we think it is being overused. There are 3 million patents in force in the United States. 350,000 new patents are issued every year. Less than 1,000 of them are reviewed in the IPR process. That's, I believe, 0.2%. It's a pretty small number, and that seems pretty reasonable.
Just to follow up on that quickly, we've seen, I think there's been instances where it looks like, I agree with you, that is a very important process, but it seems there's been instances where the International Trade Commission doesn't really respect what PTAB is doing, and and is there, what can be done about those kinds of things? How do you sort of?
You mean the same way the Federal Circuit kind of looks at the Supreme Court and goes, "What a bunch of idiots!" every once in a while?
Well, there is a disconnect here. How do we make that? How do we get past that disconnect to have a system that works for everyone?
That's a question for Bill. I am definitely not the guy to answer that question. I mean, I think the answer probably has a lot to do with getting these cases out of the ITC, or having your review for public interest done at the front of these cases. The things that are in the Delbeni-Schweikert bill, I think, would do a lot to solve the problems. They wouldn't solve the interplay problems you're talking about, but they would solve the problems at the ITC that come out of the failure of the ITC to respect what's happening at the PTAB. I think that's my amateur answer to that. Bill probably has a much smarter, Tara probably has a much smarter answer as well. But that's my amateur answer to that question. Yeah,
and thanks, Bo. And I think it does sort of break things down into, there's 2 things we can look at. One, what can be done at the ITC to make the ITC work better with respect to these questions? And then the second question is, do we need something that you mentioned, the Delbeni-Schweikert bill? Do we need a legislative response to this? But for the first half of the question, Bill, what, if anything, can be done to improve what the ITC is doing and how it makes its decisions?
Well, I think first we have, before we talk about the statute, I think the ITC, before we talk about statutory changes, the ITC can take a look at its own statute and decide exactly what it thinks domestic industry means when it comes to licensing, and how much post assertion licensing you have versus how much licensing needs to new innovation. They're going to look at just under their own statute before they do anything. The second thing the ITC might consider is looking more closely at what the PTAB is doing while it's doing it. The PTAB has, in every single IPR case, has 3 APJs. We talked about an ALJ. An APJ is an administrative patent judge, and as you said, that's a person who has competence in law as well as technology. And some of the APJs that we have at the patent office are, I would say, extraordinarily good at understanding the technology in front of them in a way that perhaps our commissioners are not. So I think when it comes to the PTAB, once they've made a decision, even an initial decision to institute a review of a patent, the ITC should take a look at whether or not they need to be involved at all. And if they do, they need to look at when their remedies should go into effect. Now, to their credit, if the PTAB has completely finished their work before the ITC gets started, they may well hold an exclusion order in abeyance. But I think Tara can tell you, holding an exclusion order in abeyance means I just spent, you tell me $10 million defending the suit before I got to that stage, and the pressure on a company to spend $10 million to fight a suit when they think the patent is no good is an extraordinary lever in settlement negotiations. So I think the ITC needs to take another look at that. Now, if you want me to talk about what Congress is doing, or has proposed in the AAIA, I will, but Wayne, maybe you want me to shut up and let somebody else talk.
Well, yeah, I mean, I think that was a good overview of what we can do. And, and there have been other things where, maybe taking the public interest concerns a little more serious, maybe, engaging them a little bit earlier in the process. Those are things that we could see speeding up and making a little bit more rational the approach that the ITC takes. Maybe Tara, maybe I'll turn to you to talk about what you think of the legislative efforts that have been underway, and they seem to be stalling a little bit, but I think there's enough interest that's starting to come behind this issue that we may see a renewed push to get a legislative solution to some of these questions.
Yeah, no, absolutely. So auto innovators, like, a number of stakeholders have been very supportive of the Advancing America's Interest Act. I believe the bill number is HR 5184. I had to look it up earlier today because I'm so used to just referring to it by its name. But no, we definitely think it's important for the ITC to have, in addition to looking at its own statute, as Bill mentioned, I think having a bit more congressional direction to look at how they handle licensing when entities are not involved in any R&D or manufacturing or other forms of commercialization, whether they, meet that domestic industry standard, whether, the public interest evaluation, that they have to make an affirmative determination of public interest before they issue an exclusion order. And I think maybe something that also kind of reiterates that maybe that public interest evaluation should be done earlier in the process, as we've already established. But one of the other things that the Advancing America's Interest Act also does is it addresses this issue that's emerging in these ITC investigations, where these licensing entities, in addition to relying solely on their licensing activity to establish domestic industry, are also subpoenaing, you can tell I'm not a lawyer, subpoenaing U.S. companies to participate in their ITC proceedings in order to establish that domestic industry. So they are kind of taking two different approaches, and you can only imagine for a company that has no interest and is very unwilling and has no stake, quite frankly, in an ITC proceeding, to get a subpoena and then be kind of forced to participate in that process, which, as Bill already established, is fairly expensive. It's not cheap, despite the fact that it can be a bit more accelerated than, say, what may happen in district court or at the Patent Trial and Appeal Board, is very concerning. So it's very helpful that the Advancing America's Interest Act also addresses that. So I think we're very, like I said, we continue to be supportive. I think also one area that we as an industry have identified, and we're obviously open to additional feedback on this. I think there's going to be a lot of discussion amongst the stakeholders as to if there's additional language or additional changes that may go into the legislation as we move forward into the new Congress. But we also have concerns, again, going back to that issue of the small part keeps out the larger product. We want to kind of see if there's a need to address that statutorily. So we have offered some draft legislative language that would say, for example, if the allegedly infringing part, the quote unquote small part, is less than or equal to 10% of the overall larger product, then an exclusion order should be disallowed. And so, because again, in the automotive space, we are increasingly seeing small components and the complainants alleging that infringement on these small components should lead to vehicles being entirely excluded. And I want to give kind of an example really briefly. So there was a complaint filed just late last month where it was related to semiconductors and microchips and infotainment. So similar to one of the examples that Bill cited. And they are asking for the exclusion of an entire vehicle line of one manufacturer and then an entire class of vehicles for another manufacturer. That is a significant remedy. And going back to Bo's point about the fact that the ITC, even though they make these determinations related to patent infringement, they do not determine the validity of these patents. And one of the things that we're finding, and I think both stakeholders and others as well, is that a lot of times that non-practicing entities are asserting infringement. They're asserting infringement on patents that from our perspective should never have been granted. So it really goes back to that question of interplay, where we want to see better patent quality, so that maybe that's also another area. And talking about the PTAB and the PTO, we are very encouraged, if you will, by the new director's interim guidance on discretionary denials. So very briefly, this is a practice that originated with the last director, saying that the Patent Trial and Appeal Board could use their discretion to not institute an inter partes review or a post-grant review if there was a separate proceeding going on, potentially in district court or at the ITC. Fortunately, the interim guidance issued by the current PTO director says specifically that the an ITC proceeding would not be a factor considered for discretionarily denying institution. And why that's important is it even cites that the ITC doesn't make determinations of patent validity. So why should that be a factor that the Patent Trial and Appeal Board considers when deciding whether they're going to grant institution of a post-grant proceeding? So I just think it's really important, again, going to those interplay questions. We don't agree with discretionary denials at all, so we would rather that that not be a practice at all at the PTO and PTAB, but we're at least appreciative of the fact that there's that recognition of the role of the ITC and how they look at issues of infringement versus patent validity and patent quality.
Great, thank you. And that sort of touches on another topic I wanted to bring up, and that is the transparency of the process. I know there's a lot of questions about sort of an industry that's evolved around this whole practice of bringing these infringement cases, and sometimes they're funded by third-party groups, and sometimes they're foreign third-party groups. Bill, maybe I'll start with you, but just how problematic is the question of funding and who's doing what in which venues, and how do you see a way out of the current problems and ways to make it a little bit better to understand how the system is potentially gained by these large investors?
So this is a very difficult question. I'm going to start with, what's the purpose of this entire patent system? The purpose of this patent system is not to make the holders of IP rights rich. That is not the purpose. The purpose is to give advancements in science and engineering and all the useful arts disclosed to the public. And in exchange for that, we grant these patent rights. But when you get to where we are today, which is massive amounts of third-party funding, hedge funds involved, enormous dollars going into the acquisition and assertion of patent rights, you're so far from the original inventor who may have invented something for their own business or for the business they work for, and then the rights have been moved around and moved around and moved around. You're not really rewarding that original inventor at all. What you're doing is you're creating essentially a lottery system where we have all of these patents, and if we can just get one to stick, we might get that ITC exclusion order, we might get a large settlement, or we might get a large judgment in court. So one thing that the ITC could do right away, and they could take a note out of Judge Connolly's book in the District of Delaware, they can make all of this transparent. Because there's nothing more frustrating than settling with someone, and then 2 weeks later, there's another suit filed by another company with a different name. But after you do a bit of discovery, you figure out, oh, this is led by the same group that this student I just settled with. What we could use at the ITC, and really, frankly, all across the district courts, is more transparency about who is funding the litigation. A patent assertion entity that has hundreds of thousands of patents and spreads them out over a bunch of little shell corporations is not easy for an individual to track, especially if you're talking about one of those members that has only a few dozen employees. So what would be good is if the initial disclosures required in the ITC included every bit of information about the funding behind the assertion of these patents. This doesn't, the ITC could do this, I believe, with just a rule change. But if they don't do it, then maybe that's when we look to getting more transparency in the whole system, and that's a legislative.
Thanks. Yeah, and I think that there are issues of transparency that are included in the legislation. But I did want to just make a note that if anybody does have any questions, I think we got about 15 minutes left. Please put them in the Q&A chat, and we'll get to those as well. But while you're sort of sorting through your thoughts, and if you do want to issue a question for us, I just a couple of things that I wanted to also look at in terms of how to make the system better. And I know transparency is a big part of it. And the other, and I think Tara, you touched on a little bit. How do you make it more difficult to qualify for the domestic industry? Maybe saying, I think that bar was lowered over the years by the judges, where licensing became a much more prominent way to make that affiliation with the domestic industry. How could you change that? And would it be difficult to provide a new solution that would clarify that it takes more than licensing? It takes being a commercial, someone who's trying to commercialize a product to qualify in that sense.
Yeah, no, thanks, Wayne. And you've already touched upon it, that the legislation, the Advancing America's Interests Act, does address this issue as well. And I failed to mention that earlier, so my apologies. In the sense that it says, okay, well, if you are solely engaged in licensing, the patents that you're alleging to be infringed have to actually be kind of quote unquote embodied in a product that is being sold here in the US. So it's kind of creating, trying to tie that licensing activity to, the more traditional understandings, if you will, what domestic industry means when we're looking at these kind of public interest reviews. So I think that could be helpful. I'm sure there's probably maybe other ideas to kind of think through. Maybe some stakeholders would even argue that licensing shouldn't be allowed at all, but I think, as the economy has evolved, that may be too drastic of a measure. So maybe the language that is currently in the pending legislation is probably the right balance. If I could just for a quick second as well, also just to kind of double click on something that Bill said. I keep forgetting which is the right term of art. It is double click, foot stomp. I think foot stomp's a little too violent. Is that with regards to kind of this disclosure regime around, third-party funders and litigation finance companies, there's, as Bill mentioned, the standing order in the Court of Delaware. There was also, as I was looking through this, a similar order out of New Jersey with Chief Judge Freda Wolfson. And I think we also have a bit of precedent related to this more on the PTAB side or the PTO side in patent with regards to a bill introduced by Senators Leahy and Tillis last September, the Pride in Patent Ownership Act, which would have some disclosure requirements. If there's foreign owners of patents, they have to report that to the PTO and update that information every time a patent changes hands. So I'm not saying that's like a perfect analog to what could potentially happen at the ITC, but I think, this push for transparency is something that's being increasingly important throughout the patent system and throughout the various actors that manage the system. So I think it's something that we could also look to as a potential starting point for these discussions if we had to pursue a statutory remedy.
Great, thanks. Bill, and it's something we've touched on a little bit before, but maybe you could drill down into it a little bit, is the whole impact of the eBay decision. That seems to be a fundamental break in the way we looked at these cases, and it changed the ITC's role inadvertently. I think it's one of the unintended consequences of that piece of legislation. So if you could just talk about that a little bit and talk about how that changed things. And then sort of a follow-on to that is, how does that affect people who really practice a patent versus a non-practicing entity in terms of what they see when they look at these venues for patent disputes?
Absolutely. So let me take you back to 2005. The Federal Circuit had been around for a good 20 years, and they had established essentially a rule that an injunction was automatic when a patent was infringed. Didn't matter who the rights holder was, didn't matter who would be hurt by the injunction. Now, they always gave at least some words on public interest in a decision that raised that, but typically in 99% of cases, if you successfully proved infringement of your patent and the patent was valid, the Federal Circuit would give you an injunction which would stop, even in the case of the big vehicle and the little component, stop the production, sale, use, and importation of that product. In 2006, the Supreme Court looked at this and, as in many of those cases from the 2000s, said the Federal Circuit law is out of step with the general principles of law. When do we give you an injunction in the general law? It's when you're causing irreparable harm. And so for a business that's operating in the marketplace, a competitor that comes in and infringes their patent, that's someone causing irreparable harm because you're taking away market share, which may never be recovered. For a rights holder who just owns a patent and hasn't produced anything from it, what used to be called paper patents before the Federal Circuit existed, they aren't really irreparably harmed by the infringement of their patent. Now, they may be damaged, and the statute says that they are entitled to damages, which at least will be a reasonable royalty. So after eBay, many NPE cases, and particularly patent assertion NPE cases, that is, there's no business behind it other than the acquisition and assertion of patents, they could not get an injunction in any district court in the United States, whereas previously they could. So you've taken away not only a powerful remedy at the end of the case, but a powerful lever for settlement at every stage of the case. So what did they do? They looked around and said, well, where can I get the next best thing? The next best thing was the ITC. The ITC can't decide damages. It doesn't have that authority. The ITC doesn't really know what a reasonable royalty is because they never have to decide it. They can only give you an exclusion order or not give you an exclusion. So they changed practice in the district courts, but never changed it in the ITC. So many PAEs and NPs go to the ITC today and try to get that sweet exclusion order that will lead to either a big payout at the end of the case or more favorable settlement during the case. It's a weird thing that happened because by conforming the district court patent jurisprudence to the general law, the Supreme Court, I would say inadvertently, enlarged the role of the ITC because now it's the only place where many patent holders can get the remedy that's more significant in the district court. Now, as you Wayne alluded to earlier, the ITC is supposed to look at the public interest factors as well as a few other factors that could be construed to match up with the eBay patent, but they have not been. They basically kept the automatic exclusion order in place for these types of cases. So it's a weird case because eBay basically made the ITC more important by making the district courts conform to the general law.
Great, thanks. Well, we've only got a few minutes left. So what I wanted to do is just sort of have each of you sort of weigh in and say, what would be your ideal reform and how would you get it implemented? Is it something we can do at the ITC, or is it something we need to include in something like the Advancing America's Interest Act? Bo, I'll start with you.
Sure. I mean, as I mentioned throughout, I think, it has to be holistic, right? It has to be broader than just the ITC. For the ITC itself, of course, I do think, as Tara said, we'd like to see the legislation, the Dodd-Frank legislation passed. I think that's a very, very good start. It may not be a finish, but it's a very, very good start, and certainly would take us a long way down the road of some of the problems we've talked about today. However, I think that's one part of, whacking the mole here and making sure it doesn't come up there. To make sure it doesn't come up there after we whack it here, we also need to work with the new director of the USPTO on patent quality at the front end, as I mentioned, trying to improve patent quality, both by giving the agency more resources and also doing some things beyond resources at the front end to improve patent quality, making sure there is a strong IPR regimen where access is not restricted by these discretionary denials, Our position, like Tara's, is that they should not exist in the first place. Our position is they're illegal. They were created illegally, and they should be done away with. I don't think that's going to magically happen tomorrow, like I fantasize about. But like Tara, I believe the steps the new director has taken in her interim review and her opening comment period is a great step. And we're very much submitting comments ourselves in the near term and going to work with the office as much as she'll let us to try and advance the goal of moving things forward there. So a holistic solution that's a lot broader. We also thought that the new order in Waco in the Western District of Texas, where one judge could not both solicit and hog all of the patent cases to himself, therefore making himself into the sort of troll's favored judge of choice and doing 21% of all patent cases in the country, leaving the other 676 judges with nothing else to do, was a good idea. So to see the Waco court now, or the Western District of Texas now equitably distribute patent cases, it's a good thing. More needs to be done, but those are all steps that we think holistically are in the right direction, and we need more.
Great. Thanks, Bo. Tara, what are your priorities in terms of solving this question?
Well, I'm a little sad that Bo got to go first because he took all my talking points. So I'm going to just say +1 to everything that Bo said. I'm going to, maybe just add a little bit to some of the suggestions. So as he was just mentioning the order in Waco, there was a letter from Chief Justice John Roberts to the Judicial Conference at the end of 2021 that said that the Judicial Conference would look at how patent litigation cases are allocated to all the district court judges. I'm not an attorney, so I may have to ask Bill this question, but I'd be very curious to kind of see what the result of that letter is. Is there some sort of process that doesn't limit these types of orders to problematic jurisdictions, which is very helpful, but kind of make sure that this type of consolidation of patent litigation jurisprudence doesn't happen in one or a couple of districts. I think going back to the orders on transparency with regards to who's funding some of these cases, maybe looking at, can that be expanded nationwide as opposed to just being in the couple of districts that have adopted those types of requirements, like I said, New Jersey and Delaware. And I think also in these broader trend towards transparency. But I think, as Bo mentioned, we are supportive of the Advancing America Interest Act as well. We believe from the PTO perspective that, every meritorious petition that's filed for institution of a post-grant proceeding, whether it's IPR or PGR, should be granted. There should be no discretionary denials. So it really is going back to one of your earlier questions, Wayne, how do these systems interplay? Because when you are kind of tilting the favors in particular in one particular venue or fora, that does sometimes lead to these unintended consequences or sometimes unintended consequences at these other venues. So I think all the things that we've discussed today in terms of potential solutions have to be thought holistically in order to hopefully make a better system. Oh, and again, patent quality is a huge issue as well. So I agree with Bo that we need to resolve those issues on the front end, and to the extent that we can't, we want to make sure that the post-issuance proceedings, post-grant proceedings are as strong as possible. Thank you.
Great. Thanks, Tara. And Bill, we've got about a minute or so. Any final thoughts on what we do with respect to the ITC?
Well, I would say first, we've got so much good stuff out of Bo and Tara that I'm not going to repeat it. I'm going to reach deep into the bag and say there's an issue we haven't talked about, but the blog is going to cover it. We have a post coming soon on this. That is the use and assertion of standard essential patents at the ITC. This is something I think we need to just stop. So standard essential patents are ones that have been approved by a standard setting organization for example, for 5G, for LTE, for standards that people are familiar with on their own phones. And the patentee gets to be part of that standard setting process by promising to license their products on brand terms, fair, reasonable, and non-discriminatory terms. So someone is promised to license their patent, in my view, probably shouldn't be at the ITC where they can't get a determination about what a reasonable term is or a non-discriminatory term as compared to other licenses. They can't get anything but an exclusion order. And once an exclusion order is in place, the leverage there is far greater than any fair, reasonable, and non-discriminatory license. That's the final thought, and a little plug to go to the blog later on this week. I think we'll have that one up.
Thanks, Bill. And yeah, thanks for having a very interesting panel and a very interesting discussion. I would sort of double what Bill said in terms of keeping a watch on the R Street blog on ITC issues. We are putting a lot of effort into it. We're developing a database of all the important cases at the ITC that will be available to look through and just use that as a data reference. Again, as we move forward on these issues with respect to the ITC, we will be updating our blog, and we've already got a couple in the pipeline on that. So please do take a look at the R Street blog. And once again, thank you all for being here, and hope we have a chance to talk about these issues sometime in the future. Thank you.
Thanks for having us.
Thank you, Wayne.
Thanks, everybody.
Bye.